Mike Harris with What in the Law podcast is back. There's a lot going on in the world, but when I started this show, it was with the intention of talking about regular things that will actually affect people for those who are interested in how things actually are. So I'm going to talk a little bit today about plea bargains because in the criminal justice system, you cannot understand it at all without understanding what a plea bargain is, because frankly that dominates most of the cases, probably well over 90%, and any jurisdiction you go to are going to have some sort of plea agreement. Now, what does that mean? Basically, it means limiting the punishment you are facing in exchange for a guarantee that you are pleading guilty, or in some cases no contest, in order to avoid a trial. There are some other similar things where you're not actually entering a plea, but which is basically another type of plea agreement. But as we discuss that, let me kind of break it down, the general subjects of how these things work. Because basically there's three very broad categories I would break down plea agreements into as to what they are. First of that is, what are the charges going to be? Second is, what is the sentence going to be if there is going to be some agreement or limitation? And the third, which only happens in certain jurisdictions and in front of certain courts, is recommendations. So regarding number one, what are the charges? That basically is, what are you going to plead to? What severity, what level are they agreeing to in this deal? For example, you might be charged with a felony level assault for using a deadly weapon, and the plea agreement might be, we will lower that charge to a misdemeanor assault without a deadly weapon if you guarantee that you are going to plead guilty and the judge agrees to that. And in such a situation, you may have been looking at mandatory prison under the original charge, and under the new charge, you might be looking at a range of penalties where the judge can agree to jail or probation or some combination. And this is something that is very common in Colorado with DUIs, where they offer pleas to the lower offense of DWAI, or driving while ability impaired, instead of a driving under the influence. And frankly, it happens on all kinds of levels of charges, from the major felonies, including first-degree murder, where sometimes people are offered deals for second-degree murder or something else, to minor traffic cases, where you might be looking at a speeding and looking at 4 points and insurance going up, and they offer you a plea to an unsafe vehicle, which is 2 points and has a less of an insurance hike. That's another example of how charges can involve pleas. Sometimes they are a lesser degree. Sometimes they just make up a whole new charge that is a lower degree than what you are actually accused of doing, such as that unsafe vehicle example. That also happens with other types of charges, including at the criminal level and felony level from time to time. Another way that can happen is, how many charges are you going to plead to? You might have several charges, and the prosecution might offer to dismiss most of those charges if you plead guilty to one or two of those charges. And that is also something that is extremely common in Colorado and many other places. Now, the second broad category I mentioned is, what is the sentence going to be? There might be a situation where there is no agreement to lower the charge or reduce the charge, but there is an agreement as to the actual punishment. So you might, for example, be facing a assault charge and you're at a misdemeanor level and there's no required jail, based on the law, but it's a possibility, and you're afraid the judge is going to give you, 1, 2, 3 months in jail. You're afraid of, and the plea offer might be, we'll guarantee you do probation and some sort of classes, and you won't have to go to jail. In some cases, that might be a very good deal. If there are significant injuries or some sort of history, or there's something that's looking pretty bad, you might really be looking at jail if you don't take that deal. That is also something that can come into play, as I said, with the third broad category, which is recommendations. Now, whether or not recommendations even matter really depends on the judge and the jurisdiction. And recommendations can always happen. Prosecutors can always, in a plea, as long as they don't go against something they've agreed to, make a recommendation regarding the range of penalties, whether they think it should be the high end, low end of what you are facing. But as far as actually having that as part of the agreement really varies. It's something that is more common in federal court. Whether or not it matters, again, just depends. It does tend to matter a lot in federal court. In state court, it really just depends on where you are and who your judge is. Frankly, what can matter more than a prosecutor's recommendation is a victim's recommendation. That can often have a huge emotional impact, and judges often, frankly, are sometimes afraid of going against the will of a victim, especially if they're afraid there could be some sort of repeat offense, and it would look very bad if they went too soft and something came out. Now, most plea bargains, by the way, are some sort of combination of 1, 2, and 3. Usually 1 and 2 when you're dealing with Colorado. And often there is a actual stipulation for what the punishment will be, and you know everything. Sometimes it's a range, and the judge has discretion in whether or not to do something like a prison sentence or a community corrections or a jail type of thing or a probation. So that's a little bit about the basics of what plea bargains are. Certainly we can talk a lot more. We didn't even get to things about keeping things off your record with deferred sentences and diversion, but that we'll save for another topic. I will see you next time on What in the Law podcast.